Good afternoon. Welcome to the Legal Aid Foundation Los Angeles' Facebook Live event. We're here to talk about the issues employees are facing during this age of COVID-19. But before we get started, I want to acknowledge this challenging time that we're in. Many in our community are grieving after witnessing George Floyd take his last breath on camera. That image has left an indelible mark on many of us. The pain many are experiencing is very real, but so is our commitment to make a real difference. It is at this time that we in the legal services community renew our commitment to eradicate systemic racism and to stand in solidarity with those who seek justice, equity, and the renewal of hope in our communities. Thank you for taking the time and the interest in LAFLA and what we're doing to help employees as businesses return and others remain shuttered. So a little bit about what we're doing today. First of all, why are we doing this? LAFLA is a frontline law firm to underserved communities throughout Southern California. And we witnessed firsthand some of the challenges that workers faced when at the height of the stay-at-home order, and they continue to face now that businesses are reopening. So we're here to talk about some of those challenges, those patterns that we've seen firsthand as clients come to our doors seeking assistance. Second, who are we hoping will hear this message? Well, we're hoping that those joining us today are individuals who are seeking information in order to make proper decisions about unemployment, their return to work, or have questions about the changes in the workforce now that COVID-19 is our reality. But the session is also for anyone who would like to support LAFLA by joining us either as volunteers or donors to help offer solutions for those in need of assistance, and especially during this economic downturn. Finally, how will we proceed? We're going to start first with a panel discussion with two of our own staff attorneys at LAFLA who have been on the front lines answering questions from our client community, and we hope to have a chance to answer questions for those attending at the end of this session. So we will have a question and answer session at the end. Finally, while we hope to offer valuable information and point folks to some resources to be able to help, this event is not intended to provide individualized legal advice. If you have an individual legal question related to your own specific case, I strongly encourage you to seek a one-on-one consultation with a lawyer, and you can do so by starting with our online intake at www.lafla.org. If you qualify, you will receive assistance, and if not, we might be able to provide you with a referral. So without further ado, we're going to go ahead and get started here. We know that there have been many pronouncements about changes in policy that come out almost daily. And so if you're listening to this recording later, we strongly encourage you to check for updated information and advice. I want to start by introducing Matt Clark. Matt is an attorney with our Economic Stabilities Work Group. Matt has practiced in the area of employment law for almost his entire legal career, and he has helped lead LAFLA's response to client questions and concerns related to unemployment as these issues arise. He will guide us through a discussion of the types of issues coming up for employees as they get ready to re-enter the workforce, and point us to some resources here that are available for employees. Next up, we also have Annie Yu, an attorney with our Asian Pacific Islander Work Group, a group dedicated to outreach and language access in the API community. Lawyers in the API work group pursue cases on cross-sectional matters and assist potential clients to get the best guidance they can for the legal problem in their own primary language. Ms. Yu will speak to the issues of language access as we are seeing them in the employment context. So first up, Matt, I have a question for you. As we heard in the news, many businesses are slated to reopen now that stay-at-home orders are being either modified or lifted entirely in various municipalities. For many low-wage workers, however, there's never been an opportunity to stay at home or to work from home, for that matter, while others have been laid off, furloughed, or simply had their jobs evaporate. What are some of the issues that you're seeing that employees have faced while being told to stay at home from work? And what issues arise as employees seek to apply for unemployment?
Hi, Fernando. we've certainly been contacted by a lot of employees who have been attempting to access government benefits available to people who are suddenly finding themselves unable to go to work because of the stay-at-home orders or because of temporary shutdowns of their places of work as a result of everything that happened suddenly in late March and April. Literally millions of people lost their jobs in California, either temporarily or permanently. And all of a sudden, the Employment Development Department, which is used to adjudicating tens of thousands of claims at a time, all of a sudden was inundated with sometimes over 1 million new claims in a week. They've attempted to keep up, and they've automated a lot of processes that previously had to be done by a person. But as a result of the overwhelming demand for unemployment benefits and the fact that the computers can't do everything by themselves, there are lots and lots of people who have ended up in a state of limbo. They're not denied, they're not approved, their status online says disqualified, or it says, you know, you have a penalty week, or it says we need more information, you're pending. So we've had a lot of people contact us because they haven't been able to access unemployment for one reason or another, and so we've been trying to see if we can figure out what the problem is and tell them our best strategies for getting in touch with EDD, because there's really not a lot people can do there. We've also seen a number of employees who discovered for the first time upon applying for unemployment that their employer had been violating the law, and in order to pocket some of the taxes that the employer didn't want to pay to the state of California, they failed to report the wages, or they've been treating their employees as if they were independent contractors. The worst offenders in the state are the car sharing apps, Uber and Lyft, which have been repeatedly told by the state that they need to pay taxes on their employees. But those two entities, which collectively employ tens and thousands of drivers in the state, have decided to declare that none of their employees is really an employee, and they refuse to pay taxes, and they refuse to follow the law. The state is suing them, but that doesn't help in the meantime, because tens of thousands of drivers have seen their rides reduced, and they're misclassified, and so it's caused all sorts of problems, because according to EDD records, none of them has ever had an employer, because the companies haven't been reporting them. So we've been it's the same issue. We have to give people our best strategies for reporting their unpaid wages to EDD. And then there's also this brand new program. It's a different kind of unemployment. Instead of regular unemployment for workers who've been paying into the system, there's a special pandemic unemployment that's been funded by the federal government. And that is intended for workers who are self-employed or who are legitimate independent contractors, who have been forced to leave their work for reasons related to the pandemic. And so we've been assisting people with figuring out whether they're eligible for that and how to get access to it. And that new program has been extensively automated by EDD. So in many cases, it is a faster way to get benefits. And so a lot of the misclassified employees that I've referred to have now been sent to pandemic benefits, where, you know, legitimately in a normal time, they would be reanalyzed and reclassified properly so that they could get unemployment benefits. So we've seen a lot of those sorts of issues, problems with accessing benefits.
Matt, thank you, Matt. What about the situation where an employer offers someone a voluntary leave of absence, or, for example, tells someone that they can work fewer hours, or even offers them a lower wage? In that circumstance, can an employee apply for unemployment?
Well, you've asked about 4 different questions there. Let's see. Can an employee apply for unemployment? You certainly can apply for unemployment if you find yourself with your income either significantly reduced or completely stopped through no fault of your own. Okay, so I think your first question referred to people who are taking a voluntary leave of absence. The EDD eligibility rule for voluntary leaving is that the person has to have a very compelling reason for wanting to leave. It has to be so compelling that any normal employee who really wanted to have a job would take the leave under those circumstances. And they have to show that they interfaced with the employer and tried to preserve the employment relationship before they took the voluntary leave. So there are certainly circumstances where you would have a compelling reason to do that, and I mean, for health reasons or family care reasons or quarantine reasons, there are certainly circumstances under which you could have a compelling reason and you would be able to access benefits. There might be a delay if the EDD system doesn't want to automatically approve you, and you might have to speak to someone at EDD who can evaluate you. It's also possible that a person could end up getting paid when they shouldn't have been paid if they did leave voluntarily without a compelling reason, and that might be something that that could cause problems in the future. So we'll have to see.
Got it. So a little tricky there, not a straightforward answer.
No.
Thank you for answering all 4 questions there in one bundle. Now that businesses are reopening, Matt, what are some of the issues we can anticipate workers potentially seeing as their bosses request them to return to work? Are you hearing any problems related to employers asking folks to return and questions from employees?
Yes, lots and lots of those kinds of questions, and they've become more frequent as more and more businesses are opening. I mean, as everyone can see in our local community, I mean, for a long time, the only thing that was open was the postal service and the supermarket. And now we have more and more businesses reopening. You know, recently in our local area, now we have restaurants reopening for patio and dine-in service. There's all sorts of retail that's reopening. And so I've gotten questions from lots and lots of workers in lots and lots of circumstances. And it's all going to, whether they have to return is going to come down to a number of considerations. The rule with regard to unemployment benefits is that a person is disqualified for unemployment benefits if they refuse, quote, suitable work. And so if a person under the circumstances is being offered suitable work, but they refuse to take it, then they can lose their unemployment benefits. So it really depends on the circumstances. And if a person has a very compelling reason to refuse the work, then it's possible that the work is not considered suitable. Some clear-cut examples: if you're 75 years old and your employer wants you to go back to work in the restaurant where you're going to be in contact with tons of people in the public who aren't wearing masks, then you definitely can refuse that work because it's not suitable for you under the circumstances, because you're of advanced age and you're more at risk from the pandemic. The same would be true for people who have compromised immune systems or who have other underlying health conditions that make them particularly at risk, and they work in an environment where it's not going to be possible for them to protect themselves completely. By contrast, if someone is at high risk but they can do work from home, then they have no right to refuse that, because that would be considered suitable work. So a person who is being asked to return and finds the work to be too dangerous under their particular circumstances can certainly refuse. And when they fill out their EDD form that says, "Did you refuse work?" you have to say yes, and then you have to explain why it was unsuitable. And then at that point, presumably an EDD worker will get back to you, and then you'll have to explain the reason for the refusal, and then they'll have to evaluate whether you're allowed to stay on benefits. I think you also asked in that other compound question about the possibility of people whose wages are being reduced potentially, or whose job circumstances are changing in other ways. again, the underlying question is the work suitable? And so if you are working in an industry and you're offered your same job back, and the employer is taking all of the recommended precautions to protect you from the coronavirus, and you're not of advanced age, and you're not immunocompromised, and you don't have other compelling health reasons, then that could well be suitable work. However, if the employer says, well, you used to make $40 an hour, but we're actually going to be paying you $20 an hour now, that might make it unsuitable. The reason why it could be unsuitable is because if this is a job that normally pays $40 an hour for almost everybody who's working in the community, and all of a sudden the employer wants to make the terms and conditions much less favorable than those that ordinarily prevail in the community, then that person would have a good cause to refuse that because it wouldn't be considered suitable. However, if that's the ordinary prevailing wage, then it might be suitable. It's a case-by-case inquiry, and EDD is going to have to be looking at a lot of these. And I really hope that they get some more workers to be looking at these issues, because as more of these cases proliferate, a lot more cases are going to be sitting in limbo while the computer is unable to assess whether the person has refused suitable work or not. I would also point out that if someone is an advanced bookkeeper with 20 years of experience and they're used to making $60 an hour, and then they're offered work as an entry-level bookkeeper making $25 an hour, that also would not be considered suitable for that person. It really is a case-by-case inquiry, and you're going to have to explain. You're going to have to analyze yourself whether it's suitable for you to go back to work. And if you choose to refuse, you're going to have to justify that to EDD. And if EDD agrees with you, then they'll continue to pay your benefits. And if they don't agree with you, then you're not going to be able to continue receiving benefits unless you successfully appeal.
As a follow-up to that, and somewhat related, what if the employer hasn't, I'm thinking of the person who has qualms about returning to work because of some underlying condition. What if the employer hasn't instituted the safeguards in the workplace? Where should workers file a complaint if they don't feel like their employer is protecting them?
Yeah, I mean, in addition to refusing your work and informing EDD that you had to refuse the work because it was unsuitable because the employer was refusing to protect your health, you can Google Cal OSHA, the Occupational Safety Hazard Monitoring Agency of the state of California, and you can file a complaint informing them that your employer is refusing to follow its legal obligations. Employees are also protected from retaliation under the labor code if the employer is ordering them to do something that is not safe. Then certainly the employee has a right under the labor code to refuse that work. And if the employer takes retaliatory action against them, such as demoting them or punishing them or terminating them, then they would have a cause of action for retaliation that they can bring to the labor commissioner or to the courts.
And what about employees who are being called upon to take care of a loved one who may be sick or have children at home and have no option for childcare at this time because daycare centers are closed? What rights do they have, if any?
Yes, again, this is going to be part of the same analysis as that we were talking about in the first question, which is, do you have a compelling reason to leave work? Because if your employer is starting up again, then you have a job. Or if your employer never stopped and you have your job, but you need to leave your job. If you quit your job, you have to show that you had a very compelling reason to do it, and you have to show that you explored all reasonable options with the employer before you quit. So under the circumstances that you mentioned, if you do have childcare responsibilities that you cannot reasonably meet under the existing circumstances, then that could potentially be justification for for quitting your job, but you're going to have to show that you really explored every feasible alternative. I mean, we're coming into the summer, so I mean, children would be at home under normal circumstances, and so you have to show that all normal options that you would normally employ to get childcare during the summer are not available to you. And if you can make that showing, then certainly you would have good cause. But if you can't make that showing because, say you have a non-working partner at home who can watch the children, or whatever your normal procedure would be, if that's still available to you, then you're not going to have good cause.
Thank you for that. Annie, thank you so much for being so patient. I want to turn to you next. Often employment resources out there can be difficult to access for anyone, but especially for someone who's has limited English proficiency. What are some of the challenges that you're seeing within the API work group that employees with limited English proficiency are facing?
Well, as well aware that California actually has a large API immigrant communities, especially in the LA areas. And a lot of them actually lost their jobs literally overnight because of COVID-19. And they didn't know how to apply for unemployment assistance because EDD's website is currently only in English and Spanish, and they just don't understand how to navigate the websites. And EDD's phone lines and their language lines have been impossible to get through, especially at the beginning months of the COVID-19. And I had a client who actually made over 1,000 attempts over a course of a week, and without any success of getting through the Chinese line that they have. So the only way they can apply is through the online portals, but so we find that they have to rely on their friends and family to apply. And the problem that we're seeing is that the applications could be incorrect. And that could result in potentially overpayment penalty down the line. And I had a client who was actually an independent contractor. He should have waited for the PUA benefit, which rolled out in April 28th. He relied on his teenager son, who applied for him early April. Of course, he wasn't approved, and he didn't understand why. He just anxiously waited for many weeks. And that caused tension between he and his son. He kept on accusing his son of doing something wrong until he called our Chinese hotline, and we explained to him that you applied too early. As an independent contractor, you should have waited for the PUA program, which rolled out in April 28th. And eventually, when we reapplied for him, he did finally get his benefit about a few weeks ago. And we're also finding individuals, LEP individuals with a limited English proficiency, resorting to paying someone to apply for them. And I have heard of fees anywhere ranging from $20 to almost nearly $1,000. There's also cases where people are having 10% of their weekly benefits deducted by these services. And we actually also assisted another client who was a former client of LAFLA. She's a DV survivor and also and she almost paid $800 for one of these services. And luckily that she found out about our assistance, and we were able to assist her with that. So there's just a lot of chaos and confusions within the community that we witnessed.
And in terms of language access resources out there, it seems like the Employment Development Department, EDD, is one of the key resources that people often turn to when they're facing unemployment issues. How responsive has EDD been to language access concerns?
Well, the state and federal law actually mandates that EDD provides LEP individuals with what's called meaningful language access to their service. However, that we have found that EDD service delivery systems for the LEP individuals have been very inadequate. And our special counsel, Joanne Lee, together with the Economic Stability Unit and also the API units, have written demand letters to EDD. We're also in communications with them, requesting improvements. We're asking them to translate their websites and their application portals to other languages, because currently it's only in English and Spanish. And the response that we received was that they're concerned with the issue, but they are they haven't taken any real actions to do anything. Their response to us was that their infrastructure is old, it's going to be time consuming and difficult to change it at this point. But we have gotten them to agree to at least translate some of the COVID-19 informations into different languages so that people with LEP can actually understand with such a fluid situation we have right now. So we're looking forward to see those materials on their website.
Thank you, Annie. I imagine it's also especially challenging right now because many folks don't have the opportunity to just go into an office and speak to someone at a reception counter to get some information. What kinds of patterns have you seen, Annie, in terms of reopening for employees with limited English proficiency? Are there gaps in information related to safety, for example? And if so, what are the resources that someone in that situation can access to get language appropriate information about how to protect themselves when they return to work?
Okay, that's actually another issue we're seeing a lot in the API communities. People are calling our hotlines asking, can I refuse to go back to work if I feel unsafe? And there are actually quite a bit of information out there on EDD's website, but the problem is that these LEP individuals don't understand. So they often are just very confused and scared. So we just tell them that it's case-by-case situation, like Matt said earlier. It depends on whether or not they're refusing a suitable employment with a good cause. If they're over 65 years old, if there's underlying health issues. So these are all very good informations, but these LEP or API communities, they don't understand these informations. So it is important that EDD translates these critical information so that the API communities doesn't have to live in fear and anxieties about whether or not, they have to return to work. And I actually found on CDC's website, they actually have some translated materials on reopening guidelines for safeties at workplaces. That's translated into Chinese, Korean, also Vietnamese. So I think that would be a good place for people to go. And they also can call our Chinese hotlines or Korean hotlines. We actually have dedicated API language hotlines in Chinese, Korean, Vietnamese, Japanese, and Khmer. So we could advise them according to their own situations.
Thank you, Annie. You actually answered my next question, which was, what other resources are out there for the API community? The links that you just mentioned, we'll go ahead and make those available in the comments section for those attending this session. Finally, Annie, are there any other places where you that you direct callers or clients to when they're seeking information in the API community related to employment?
I also noticed that in addition to the CDC's website, Department of Fair Employment and Housing websites also has translated materials in different API languages, in Chinese, Korean, Vietnamese, and Tagalog. It's the frequently asked questions for employment information on COVID-19. I think those would be very valuable resources for people who have limited English proficiencies. And also, there are actually ethnic community-based organizations such as Chinatown Service Center, KYCC, the Korean Youth and Community Center, that are providing free assistance for people applying for unemployment assistance. And also, of course, there's always LAFLA's API groups. We are also providing free legal assistance for the initial UIB and PUA applications, and also we're providing counsel and advice on employment-related issues. When people called in, we actually give them assistance in their preferred languages.
Thank you for that. Matt, turning back to you, in terms of the cases that you're seeing through the Economic Stability Work Group here at LAFLA, there are probably a number of questions that I anticipate callers are asking related to what an employer can and cannot do once they return to work. What are some of the common issues that you're seeing as employees return in terms of what their employers have done with the workplace and their jobs?
Yes, yeah, we have received some questions, and probably we're going to receive more because the normal rule in the workplace is that the employer is not allowed to invade your privacy unreasonably, and the employer is not allowed to discriminate against people because of disabilities or medical conditions, and the employer is generally not allowed to invade your privacy at all. So when people get back to the office and they're told, oh, you have to take a coronavirus test, or we want you to take your temperature every day, or we want you to stay home from work if you have a cold-like symptoms, or, you know, we want you to wear a mask. I mean, these are all totally unfamiliar infringements on our personal, I mean, even our personal bodies. And so it's unusual and surprising for a lot of people to have the employer making these kinds of inquiries. From a legal perspective, the rules with regard to discrimination is that the employer is not allowed to discriminate against you unless they have a really good reason. And the same is true of invasion of your privacy. The employer is not allowed to unreasonably invade your reasonable expectation of privacy. But in all of these cases, the law does come with seldom used exceptions for when there are, you know, really compelling circumstances. And when it's called the tests are job related and consistent with business necessity is the legal term of art. And what that means is that if the circumstances are such that there is a medical test that the employer can show that it really needs to take in order to provide the healthy and safe workplace that we discussed earlier, and in order to, you know, protect the public, because the employer has responsibilities to the public too, that does give the employer a compelling reason to do some of these things. And nobody has litigated any of these issues yet, because we've only been in a pandemic for a few months of any of our lives, and so these are all, you know, brand new questions. However, the Department of Fair Employment and Housing has started to answer some of them, and the Equal Employment Opportunity Commission, which is the anti-discrimination branch of the federal government, has actually answered even more of them. And what they've told us is that, in their opinion, the employer does have a compelling reason to protect the safety of other employees and to protect the safety of the public. They do have a compelling reason to ask people to take coronavirus tests. They do have a compelling reason to ask people to submit to temperature checks on a regular basis. They do have a compelling reason to say, you know, even if in 2016, if you had a little sniffle, you might have come to work. If you have any kind of symptoms that could conceivably be related to coronavirus, you need to get tested and you need to stay home. And maybe you even need to stay home for 14 days. The employers have a responsibility to follow the CDC guidelines and the state health department guidelines, and to do the best to protect the public. So to the extent that they can say they're following those rules, then it's not going to be an unreasonable invasion of your privacy, and it's not going to be considered disability discrimination.
Thank you. Yeah, you actually answered my next question that I had. I did want to ask, though, you know, in terms of returning to work, if an employer has changed some of the circumstances of a worker's employment, what remedies does an employee have? Say their job title changed, their assignment, their location. What remedies do folks have in that circumstance?
Well, so you're saying if the employee is back at work, but for whatever reason, certain aspects of their work have changed. I mean, under certain circumstances that we discussed earlier, a person's work might have become so substantially less favorable than what is normally prevailing in the community for that kind of work, that the person might have a compelling reason to refuse that work and to stay on unemployment while they search for more suitable work. In terms of what I think you're implying, which is whether the employee might have some kind of anti-discrimination case, if you could show that the only reason that the employee was being given this less favorable assignment was because the employer had a hostility towards people that it perceived as having some kind of physical weakness or potential medical condition, then I mean certainly that could be analyzed as a kind of invasive discrimination, and it could be reported to the authorities. I mean, I was just saying that the employer does have a duty to the public and to the other employees to protect people by engaging in reasonable compliance with health guidelines, but the employer doesn't have unfettered discretion. I mean, if the employer has some unreasonable belief that you might have coronavirus and it wants to punish you for that, then that could be unlawful discrimination, because the employer is not allowed to act based on perceived disability on the part of the employee, and so that could be unlawful discrimination. I've also been asked whether employees can discriminate and say, we want everybody to go get an antibody test, and everybody who has antibodies for coronavirus, you can come work, and everybody who doesn't have antibodies, sorry, you're potentially infectable with coronavirus, so you can't work. I'm pretty confident that would be going too far. Because no government agency has ever even suggested that employers ought to think about conducting antibody screenings. So the idea that an employer would just be following the rules is not something that they can rely on. There's also some old cases from Title VII where employers tried to say that people who might get pregnant someday shouldn't work in this battery production department because they might damage their systems, and the Supreme Court unanimously said that it's not up to the employer to decide what risks employees are going to assume in the workplace, and they're certainly not allowed to use invidious discrimination categories in order to make those kinds of decisions on behalf of employees. So I don't think that a coronavirus antibody screening is going to be allowed, and I certainly don't think that an employer is going to be able to say to someone, "I'm sorry, you look like you're weak, and therefore we don't think you'd be able to handle the coronavirus, so we're firing you." That would be a kind of perceived disability discrimination. So there are definitely limits to what employers are going to be allowed to do. We don't have any cases yet because, again, this is a recent development, but I think we can infer some of those limitations from our past experience.
Thank you so much. Thank you. Well, thank you both for your time. Annie, I wanted to turn back to you for just a moment and ask you, if someone were in the community were seeking the services of the API unit, what's the best way for them to access those services in the language that they need?
Oh, you're referring to LAFLA service?
Correct, yeah.
Okay. We have dedicated language lines, so they actually can just call our language lines directly. It's actually answered by bilingual staff. It could be a law student, attorney, or paralegal. And we could do the intake systems through our hotline directly. So they don't, if they can also actually go to LAFLA's online websites. Our online applications actually also translated into Chinese and Koreans. So they actually can go through all the questions and complete the online application on our website also. So either way is fine. They can do the LAFLA websites or call the LAFLA dedicated language lines. And I think our phone number is listed on our website.
And once again, for those listening in or perhaps viewing this later, we will be posting all of that information on the comments section so that folks have access to it after we wrap this up. Finally, my name is Fernando Gaitan. I'm the Director of Legal Training and Professional Development at the Legal Aid Foundation Los Angeles. You've just been part of a Facebook Live event for LAFLA. We hope you'll join us again in the future as we put out these informational sessions for the community. We hope you stay safe, and if you need access to any of the information you heard today, we will be posting that in the comments section. You can also visit our website at www.lafla.org. Thank you both for your time. Thank you everyone who attended. And for anyone who, and we did get a comment from someone who wants to volunteer, thank you for that comment, and thank you for your interest in LAFLA. Please go to our website and you can click Get Involved and find ways to volunteer at a clinic or one of our projects and support us in that way. So thank you all again, and stay safe.